record. Okay. Okay. We'll go on the record in the Yoakum matter, CR 2024-289. I'll note the presence of counsel and the defendant. Let's see here. Okay. Our jurors are here, but they're not in the courtroom with us. First, Mr. Crawshaw, were you going to upload an additional exhibit?
No, that time passed.
Okay.
But thank you for asking.
Okay. So, Madam Clerk, we can go ahead and re-shut the digital evidence portal. Mr. Crawshaw, do you intend to call witnesses?
Just one.
And who do you intend to call?
Mark Gatz.
Okay. Just a quick prelim, and is he here?
Yes,
okay.
Sir.
So let's talk through, you'll call Mr. Gatz. Ms. Ortman, do you anticipate any rebuttal?
Probably not.
Okay. I will ask you after we're done, after the defense rests. So I'm suspecting if we start a few minutes after 9, Mr. Crawshaw, do you think Mr. Gatz probably half an hour or less? I don't know which.
Less.
Okay. So we'll finish that. Then at that point, I'll excuse our jurors so we can finalize finals at that point. Hopefully either last night Veronica sent you the latest draft or this morning I sent out another copy. I think that incorporates both the two, or the one you sent, Ms. Ortman, with some small changes because of the way it is. And then Mr. Crawshaw had included yours. There's still lots of things we need to talk about on those. And there's some ones now separate counts, like those will need to go away, but that's the most recent draft. But I just want to verify, Ms. Ortman, you do have those?
I do.
Okay.
And I've reviewed them this morning, and while we're talking about them, I didn't see, and I'm not certain that I always forget to request this jury instruction, but the Raji for redacted exhibits, I didn't see that in there.
Okay.
And
Do we have redacted exhibits?
Yes, the interview of Mr. Yoakum is cut short. And then there's a portion cut out during the transportation, and so I don't want them to speculate as to what could have been cut out.
Okay. I will work during one of our breaks. If you have someone, I don't know if you can get a number or Raji quickly, that would help me. I'll just pull it off the Raji website, but I'll put that in there. Mr. Crawshaw, do you see any, I mean, we'll take whatever time we need to go over them, but you've had a chance to review them in advance? The draft instructions?
Just briefly.
Okay. So if I tell the jurors that after we're done that we'll probably give them a 45-minute break, do you think that gives us time to go over the finals? We'll need to make copies, and then you can prep for your I'll do those, and then you'll do argument. Do you think that's a good guess of time?
Yes, sir.
Ms. Ortman?
So you're talking about doing closings today, or?
I think so. I mean, if we're going to be done with evidence,
We'll be done with evidence before 10.
we'll be done with evidence before 10. I think we could potentially do it, we could do closings before the noon hour.
I just know Mr. Crawshaw needed to leave early today. We had talked about that on the first
I just need to leave by
5?
5.
Okay. So what I would do then is I'll probably tell the jurors when I excuse them that we may ask, if the case is going to them for deliberation, we may ask them to deliberate during the noon hour, so please let their family or whoever know. And then when we excuse them to deliberate, I'll let them know that if they want to deliberate tonight, they can deliberate up to 5. If they need it more time than that, we'll come back next Wednesday. That way we can go from there. But I think we're on track to be done today.
Okay.
Okay.
And, Your Honor, are you going to read them the use note for the dismissed counts? Are you going to read them that? The use note says that it should be read to the jury upon dismissal of the counts, or also in finals?
I was just going to leave it in the finals, since I don't think there's going to be a reference to it between now and when finals will be.
I mean, it's such a short period of time, but
Okay.
the use note does say that is what should be done, and so.
Okay. Do you think, because the charges, if the charges were very, very different, there was a gun and drugs in the gun, then I think I would do it now. But since the charges really sort of overlap each other, I don't think I need to.
And there's also such a short period of time.
Okay.
too.
Do you have any objection if I just give it at the finals? Okay.
No, Your Honor.
Mr. Crawshaw, any objection to that?
No, sir.
Okay. Okay. Then, okay, Mark, let's line them up and bring them in.
Jurors coming in.
Okay, please be seated. Okay. I'll affirm that we're on the record in CR 2024-289, State versus Yoakum. I'll note our jurors have joined us this morning. Thank you for returning. Thank you to both you and counsel for being ready to go right at 9 o'clock. When we had concluded yesterday, the state had rested. Mr. Crawshaw, would the defense like to present any additional evidence?
Yes, please.
And who would you like to call?
Kenny Yoakum calls Mark Gatz.
Okay. And if you want to get Mr. Gatz. Is he on? He's on his way.
He's coming through security, Your Honor.
Okay, thank you.
While we're waiting, Judge, may I have permission to publish State's Exhibit 9?
Let me just take a look at where we're at. Just pull up where we're going. And 9 has been admitted?
Yes, sir.
Okay, Ms. Ortman, any objection to that?
No, Your Honor.
Okay, and is it pulled up on your screen?
Yes, sir.
Okay, let's give control to Mr. Crawshaw. What happened? Okay. Good morning, Mr. Gatz. If you'd like to make your way up back to where the bailiff is. Okay. And then before you sit down, I'm going to ask the clerk to swear you in again since it's a new day, okay? So if you can raise your right hand.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay. Go ahead and have a seat. And I don't recall, did you use the hearing assistance yesterday?
Yeah,
Okay.
just a little something.
Okay, why don't you go ahead and get those settled on, though?
Okay.
Okay, can you hear us okay? Mark, can you make sure he's on the right channel?
Okay.
Sometimes it should be on 3, I think. Okay, can you hear us now? Can you hear me now?
Yeah, it was steady, but I can hear you.
Okay. Okay, and maybe put that in your lap or around your neck, because when it gets with another electronic devices, it gets extra static.
Okay.
Okay, Mr. Crawshaw.
Judge, can I stand up?
Yes, please.
Mr. Gatz, can you hear me okay?
No, it just went off on me. I don't know why.
Naturally.
There it went.
Okay, can you hear now?
Yeah, yeah.
Okay. Mr. Gatz, how long did you live in the woods approximately in this area?
About 6 years.
Okay, are you familiar with it?
Very.
Okay. About where was your camp at the time? Am I pointing to it?
Yeah, yes, sir.
Okay.
Yes, sir.
Okay. Right about here?
Yes, sir.
Okay. So your understanding, were there any fires up here?
Not that I know of, no.
Okay. Did you see Kenny down here?
Yeah.
Okay, and you lost sight of him about right here?
Yes.
Okay. And then what's over here? What sort of landscape features?
The road.
Hey, and I need you to get by, just a second, I need you to get by the microphone, sir. And if you need to pull it over, you can. I just need to make sure you're talking in it so we can hear you.
Okay, I'm sorry.
That's okay.
It goes north and then it makes a hard right, goes into a deep ravine, and then comes up the other side, and that's pretty much it.
Okay.
Okay. Why don't you try those, sir? I want to make sure that you're not guessing on anything. We want to help you.
I appreciate that.
Okay. Okay, is that better?
Yeah. Oh,
Okay.
yeah, yeah.
Okay. Mr. Croshaw, you may continue.
Thank you, sir. Your camp is right here,
Yes, sir.
and it's facing, I'm not going to use cardinal directions. Can you just go with me for a second?
Sure.
Okay, because cardinal directions get confusing because the road doesn't follow a due course.
Okay.
Your camp is facing, if you will, this way, correct? Towards the top of this map.
Yes, sir.
Okay. Did you see Kenny walk up here?
No, sir.
Okay.
No.
Did you were out there with fire personnel, correct?
Yes, sir. Yes, sir.
Did you see any fire personnel up here?
No, sir, I didn't. No.
Along this course, can you describe the terrain?
Very steep, very rugged, and very thick in bush and trees, and very rugged, very, very rugged.
Okay. And so your camp, being at about this level, looks right out onto this area.
Yes, sir.
Okay. Pass the witness.
Ms. Ortman, any cross?
Sir, in the state's case in chief, the first time you testified that going through this area was a bit of a shortcut, right?
Partially, part of it, yeah. Yes, sir.
Part
Yes,
of
ma'am. Yeah.
a shortcut, because the road, if you're walking on the highway through there, is dangerous, right?
Yes.
So people will cut through if they're going towards Strawberry because it's a safer way to travel, right?
If they know the terrain, yes.
Okay. I don't have any other questions. Thank you.
Any redirect?
No.
Okay. Members of the jury, do you have any questions for Mr. Gatz? Okay, I don't see any. Mr. Croshaw, may Mr. Gatz now be relieved of any obligations under any subpoenas at this
Yes, sir.
point? Ms. Ortman?
No objection.
Okay. Sir, thank you for being here again today. If you just want to leave that headset right there.
Sure.
And you can just leave it on. Mark will turn it off in a minute.
Okay.
Thank you. Have a good rest of your day, sir.
God bless you all.
Okay. Did you get all his items? Did you get all your items, sir? Yeah. Okay. Okay, good. You're all done. Mr. Croshaw, you may call your next witness.
The defense rests.
Okay. Ms. Ortman, does the state wish to call any rebuttal witnesses?
No, Your Honor.
Okay. Members of the jury, what that means is that you've heard all of the evidence that's going to be presented in this case. We are quite a bit ahead of schedule, which I don't think anyone is complaining about. What I need to do next is I need to speak with the attorneys for a few minutes so we can get your final instructions done, because I can't do those until the completion of evidence. So I realize you just came out about 10 minutes ago. You get your first morning break, and it's going to be a little bit of a long break just because I need to make sure I get those instructions done. I'm sure you can see from the preliminaries, it's not like 1 or 2 pages, okay? So I'm going to excuse you. We're going to target, it's going to be 45 minutes, so 9:55. I told you it'd be a little longer break. It's going to be 9:55. Let me give you a little bit of an idea of what's going to happen the rest of the morning so you know. When you come back at 9:55, I will give you your final instructions in the case. The attorneys then will give their closing arguments, and shortly thereafter, I'm going to excuse you. You'll begin your deliberations today. I will ask you to, since I don't know exactly what time I'm going to send you back to deliberate, but it's going to be within an hour or two of the noon hour. I mean, an hour this side or during the noon hour. I'm going to ask that you deliberate during the noon hour today. We'll actually order food if you're deliberating during the noon hour. I tell you that now, so if you have any folks at home or any lunch appointments, I'm going to ask that you make provisions maybe to put those off to another day. You then will have the opportunity to deliberate as long as you choose to today. And if you're not done today, then we'll come back next Wednesday, so we do have that additional buffer there. Okay, but I'll give you more specific instructions, but I do want to let you know I'm probably going to ask you to deliberate through the noon hour today. So if you have any folks at home that are expecting you, maybe give them a call or a text now and let them know you're probably going to be here through the noon hour today. Okay, so I'll excuse our jurors. I'll target 9:55 to call you back. Thank you. Okay. Counsel, if you'd like to approach, I have an additional, I was able to, before the jury came in, pull up the redacted exhibit, Raji, so you can take that, and then we can talk about. Okay. Okay, so if you both want to pull up a copy of the draft finals that went out last night, we'll go through those now.
Just need 1 moment. Okay.
Ms. Ortman, you have yours pulled out. Mr. Croshaw, you have yours?
Yes, sir.
Okay. So we'll take some of the first groups in chunks, as I don't think there's anything controversial on those. Ms. Ortman, any issues with standard 1, 2, or 3?
No, Your Honor.
Mr. Croshaw, any issues with those?
No, sir.
Okay. Ms. Ortman, any issue with standard 4A or 5?
No, Your Honor.
And I'll note on 5, I have changed the wording, I believe, in the second paragraph, slightly just to read a little better. That is a slight variation, but I don't think it's substantively different. Okay. Mr. Croshaw, any issues with 4A or 5 as I have them drafted?
No.
Okay. Okay. Ms. Ortman, any issue with 8?
No, Your Honor.
Mr. Croshaw with 8?
No.
Okay. Mr. Crawshaw, on 9, do you want all, some, or none of 9?
All of it.
Okay, so you want to leave in, the last sentence says the defendant's decision not to produce any evidence is not evidence of guilt. You still want that in?
Yes.
Okay. Ms. Ortman, any issue with 9?
No, Your Honor.
Okay. Ms. Ortman, any issue with 10?
No, Your Honor.
Mr. Crawshaw?
No.
Okay. And Counsel, 11 is stipulations. I don't believe there have been any stipulations, so I'm going to go ahead and remove 11. So the next one would be standard 13, which I just handed out to you. Ms. Ortman, you had requested that. Is that the instruction you were looking for?
Yes, Your Honor.
Okay, and any objection with 13 as is?
Well, it cuts it off at the end. Do
Oh.
not concern yourselves with reasons why. It's not a complete sentence.
I wonder when I was cutting and pasting if I lost that. Oh, I missed it. Okay, so what it will say, and I thank you for catching that. For some reason, when I was copying it, it didn't let me do that. Control C, space, Control V. It will say in its entirety, some of the exhibits have been admitted into evidence. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourself with the reasons why some portions of the exhibits have been deleted. And then the final sentence says, do not speculate upon what the deleted portions might or might not reveal. And that's the Raji. Ms. Ortman, anything else?
No, Your Honor.
And Mr. Crawshaw, any objection to that?
No.
Okay. And counsel, just so we're all on the same page, I'll leave in the titles to these, but I will take out the standard criminal 13, that type of thing. Okay. Standard 14, Ms. Ortman, any issue with that?
No, Your Honor.
Mr. Crawshaw?
No.
Okay. Standard 15 mirrors what I gave them in the prelims. It does have slightly different formatting than standard 15 with the bullet points. Ms. Ortman, any issue with that?
No, Your Honor.
Mr. Crawshaw?
No.
Okay. Okay. Standard 16, Ms. Ortman, any issues?
No, Your Honor.
Mr. Crawshaw?
No.
Standard 17 is expert witness, and I think at least as to the estimate of value, there was that expert. I don't recall if anyone else testified in an expert capacity, but I think it does need to be given. Ms. Ortman, any issue with 17?
No, no, Your Honor.
Mr. Crawshaw?
No.
Okay. Okay. Mr. Crawshaw, how much, if any, of 18A would you like given?
All of it.
Okay, so I'm just going to take out the brackets on the final sentence. Okay, and then I'm going to eliminate 18B as the defendant did not testify. Okay. And then 19 would be statements made to law enforcement in advance of the trial. Ms. Ortman, any issue with that?
No, Your Honor.
Mr. Crawshaw?
No.
Okay. I'm going to remove standard 30, as there's only one count now for our jurors. Okay. Standard 31, Ms. Ortman, any issues with that? And I have modified it slightly just so it reads, and you can either use count numbers or charges, but I've made it count numbers.
And I don't object to that, Your Honor.
And
Word standard 30?
31. And let me just, if
No.
you, okay. Okay. Moving on to standard 43, mere presence. I believe in the, Mr. Crawshaw, this, you requested it. I think, hopefully you received highlighted in yours. I don't think the highlighted language is necessary, but Mr. Crawshaw, I'll hear from you first.
The highlighted language is not necessary.
Okay, so, and Ms. Ortman, would you concur with that?
I agree with that, and I think it makes it a little more easy to understand in light of the facts
Okay.
to remove those.
Okay, let me take that out, and then I'm going to read you what's left, just so we can all make sure we're on the same page. So it'll say, guilt cannot be established by the defendant's mere presence at a crime scene. The fact that the defendant may have been present does not, in and of itself, make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Okay, take that out. 44, so next one will be 46. Mr. Crawshaw, that was your requested instruction. Anything you'd like to add or change there?
No.
And those just ended up back to back because I give them normally in the order. One was 43, Raji 43, and one's 46. Okay, Ms. Ortman, any issue with standard 46?
No, Your Honor.
Okay, and Ms. Ortman, any issue with the criminal damage instruction?
No, Your Honor.
Okay. And counsel, I'll let you look at the verdict form in just a moment. It actually will have the breakdown of the dollar amounts, but in the instruction itself, I was just going to tell them they'll have to figure that out. So, Mr. Crawshaw, any issue with the criminal damage instruction?
Just the required proof.
Okay.
What I'm asking, I'm making sure I'm referring, because this one doesn't have a number by it, but it's
Oh,
on
yes.
it's on my page 22.
I don't know what page it is now because I've been changing them as they
Oh.
go, but it starts criminal damage. The crime of criminal damage requires
Yes, I
proof.
don't have an issue with that.
Okay. The burning of wild lands, I'm going to take out the entirety of that. Okay, now as we get to definitions, let me go back.
I think we only need recklessly to go to them.
Yes, so, well, but I have to leave the others in because if you prove intent or knowledge, then it goes there. So,
But criminal negligence can
oh,
come out.
criminal negligence. Okay, just a second. Okay. So I can take out, Mr. Crawshaw, do you agree that criminal negligence can now be removed?
Let me get the charging.
Michelle, after we're done with this, I'll do the patent court, 2 copies. I'm sure you guys have them. What's the name of that printer?
Yes.
Okay, so I'm going to remove criminal negligence. Let's see here. Shoot, let's just tap that control C. Okay, just a second. Okay. I believe we still need damage or damaging. Property of another is still needed. Property is needed, but wild land is no longer needed, so I'm going to remove that. And then, case is submitted to you, all 8. Okay, Ms. Sportman, anything else on the general definition section you'd like to ask for?
No, Your Honor.
Mr. Crawshaw? Anything else on the general definitions that we've missed now?
No, sir.
Okay. And then, counsel, Ms. Ortman, any objection, any issues with the closing instruction that I'll do after your arguments?
One,
Okay.
where is the interrogatory for values?
It's going to be, if one of you wants to come up and grab the verdict form, Mark's, I think, back with our jurors. Oh, Mark is here. Can you take a look at that, show it to Mr. Crawshaw? Thank you, Mark. Okay. Mr. Crawshaw, any objection to the verdict form?
Aren't they supposed to put in a specific amount?
Generally, I just ask them to, because the specific amount I don't think is relevant, the range is what's relevant. Are you asking that I make it where they just, if you find him guilty, they need to fill in a number? Well, I mean, I guess I could do it that way, and then I can just make a you know, are you asking for that?
Yes, I think that because it requires the jury to be unanimous on a more specific issue.
Okay. Ms. Ortman, do you have any objection to that?
Your Honor, I am concerned that they are going to confuse this. We have several people who've been on civil juries.
Okay.
I'm concerned that they are going to confuse a specific amount with this is our finding as to the amount of damages. And that's not what they need to find. They need to find in the specific ranges as the court is suggesting. And so this isn't a restitution hearing where they're determining the amount. They just need to determine what range is it in.
In the statute, may I respond?
Yeah, yes.
The statute itself describes how it is punished and gives the ranges. It doesn't instruct us. In other words, the legislature hasn't said that they have to go make a finding within of those ranges.
And Your Honor, if they don't make a finding in those ranges, then how do we know which level? Because I mean, this could be anything from what he's charged with all the way down to, I think, a Class 2 misdemeanor. And so how do we know?
Okay, hold on just a second. What amount of property damage? What? Okay. I had not thought of this before. I think Mr. Crawshaw's point of a unanimous jury is well taken. I think, because if you have, and so I think what I'm leaning towards, if you find the defendant guilty, what is the dollar amount of the property damage caused by the defendant?
Yes.
That's what you're asking for, Mr. Crawshaw?
Yes.
Okay. Ms. Ortman, would you like to be heard further on that? Because I tried to add in a few, not what are the damages, because I think that could be confusing for civil, and there were several of our jurors, but what is the dollar amount of the property damage caused by the defendant? Would you like to be heard further?
No, Your Honor, I still think that that's improper, but
Okay. Okay.
And will that specific verdict form say, like, if you found,
Yeah,
if you
so-
don't find the previous question, I don't have the wording right now, if you don't have the previous question, then don't answer the next one.
It will just say, if you find the defendant guilty, what is the dollar amount of the property damage caused by the defendant, with a line and a dollar mark? And I will affirmatively tell them that if you reach not guilty, you're done with the verdict form. You only need to get to that as it says, if you find him guilty.
Okay.
Okay, so Madam Clerk, we will need to change that eventually. So it'll be, don't worry about that. Okay. Let me do this. Since we have done a fair amount of modifications, let me save this. Council, I'm going to print you out each one more so you can take a look at them. I want to make sure that I haven't missed anything. Let me do this, close that, save. Okay, I just sent that to you, Michelle, if you can print two copies. And council, I haven't taken out the titles yet, I'll do that, I just wanted to get you to take a look at them. Let's see, did that come through? And Mark, when these come out, can you take copies to the council? Are you able to print out what exhibits have been admitted? Or can you, and is that, Mark, council, can you take a look at the clerk's notes as to which exhibits have been admitted and verify that that matches up with what you think should be in?
Yes, sir.
Ms. Ortman, are those the exhibits you believe have been admitted?
Yes, Your Honor.
And Mr. Crawshaw, were those correct?
Yes, sir.
Okay. Yeah, Mark. Okay. Madam Clerk, if you could note that the attorneys have verified the exhibits, therefore you can lock those down and do whatever we need to so they'll be available for our jurors.
Judge, may Mr. Yoakum be excused momentarily?
Yes. Well, yes, obviously with his associates. Can you put Mark, can you show this to council? Council, if you could take a look at the new draft verdict form, subject to your prior objections, if you can just verify if you have any issues.
No objection from the state, beyond what I already.
Right. No objection?
No objection.
Okay. Council, did you have a chance to look at the printed copy to see if you think there's any additional issues we need to discuss that Mark just gave you? I think I found one other issue I want to talk to you about, but if you want to glance through and just see if you think there's any, I made the changes that we discussed.
I have a request.
Yes.
It's formatting only.
Okay.
It is helpful if, disregard. I just wanted to make sure there's page numbers throughout the jury charge.
I believe there are.
In the final form.
Yes, there are.
And I thought you were taking off the standard criminal 46, standard criminal.
I am, but I hadn't taken it off by the time you printed that. While those were being printed. So I took those off. Council, let me ask one more thing. On page 21, the fourth paragraph down, if the state is required to prove the defendant acted knowingly, I don't think we need that.
Page what?
21, the fourth paragraph. I think it should just be intentional, or intentionally, here's what it means, intent is inferred, knowing, here's what it means, and then jump right down to reckless. I don't think we need that fourth paragraph, because the sixth
Yes.
paragraph covers that.
I agree, Your Honor.
Do you concur, Mr. Croshaw, or?
Where does the intentional come from?
The intentional comes from because the state only has to prove reckless, but they can prove higher states, higher mental states if they choose to. Because the mental state for criminal damage is reckless.
What purpose does it serve?
If the state is required to prove that the defendant acted recklessly, that requirement is satisfied if the state proves that the defendant acted intentionally or knowingly. So if you look down 1, 2, 3, 4, 5, the sixth paragraph on page 23, or 21, excuse me, that's, I believe, part of the Raji's under intent. So I don't know, I don't suspect Ms. Ortman is going to be arguing that I proved the harder as opposed to the not less hard, but I think that is, as a Raji, I think it should go in there.
But we're going to take out knowingly?
No, we're going to take out the fourth paragraph. We'll leave in the definition of knowingly, but after the part about if the state has to prove knowingly, they can, because there is no, they don't have to prove knowing ever. So just that fourth one. If the state is required to prove the defendant acted knowingly, I'm going to take that out. Do you have any objection to that?
No.
Okay. So I will take out that paragraph. Counsel, that'll change just as you get the instructions, then there'll be 21 pages before your arguments, and then 22 and 23 will be that post-arguments. Okay. Ms. Ortman, are you going to use technology for your closing?
Yes, Your Honor.
Okay, and so during our break, hopefully you can verify that that's working. Okay, I will go back and Mark and I will work on getting, well, I'll start printing. If you need help with tech, you can work out here, and then you can help me make copies in a minute. You're good? Okay. Ms. Ortman, anything else before we break then?
No, Your Honor.
Mr. Croshaw, anything else before we break?
No, sir.
Okay, council, let's target 9:55, which is about 15 minutes. I'm hopeful that I can get it, Mark and I can get those done by then. Okay, thank you. Please be seated. Okay. We'll return to the record in State versus Yoakum, CR 2024-289. I'll note the presence of our jurors, counsel, and the defendant. Members of the jury, you've passed in your preliminary instructions, which I believe Mark collected. I'm going to ask Mark now to pass out your final instructions. And as with the preliminary instructions, I'm going to read these to you. I'll ask that you listen. You're free to follow along on the written page as well. Okay. It is your duty as a juror to decide this case by applying these instructions to the facts as you determine them. You must follow these instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in this case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits that are introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinions that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all of these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply, together with the facts as you determine them. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty, and the plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In a criminal case such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must decide whether the defendant is guilty or not guilty by determining the facts in the case, by determining what the facts in the case are and applying these instructions. You must not consider the possible punishment when deciding on guilt. If you find the defendant guilty, punishment is left to the judge. You are to determine the facts in this case. You are to determine what the facts in this case are from the evidence produced in court. A question is not evidence. A question can only be used to give meaning to a witness's answer. If an objection to a question was sustained, you must disregard the question, and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered to be stricken from the record, you must not consider that testimony for any purpose. The state must prove the defendant guilty beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. In their opening statements, and in a few minutes in their closing arguments, the lawyers have and will talk to you about the law and the evidence. What the lawyers say is not evidence, but what they say may help you to understand the law and the evidence. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits may have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a law enforcement officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise, and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant acting with the advice of an attorney. You must not let this choice affect your deliberations in any way. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overborne by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statements as you feel it deserves under all of the circumstances. At the beginning of the trial, the charges against the defendant were read to you. Counts 2 through 4 are no longer before you. You should not speculate why these counts are no longer being submitted to you. You should only concern yourselves with count 1. Guilt cannot be established by the defendant's mere presence at a crime scene. The fact that the defendant may have been present does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. The state has the burden of proving that the defendant was present at the time and place the alleged crime was committed. If you have a reasonable doubt whether the defendant was present at the time and place the alleged crime was committed, you must find the defendant not guilty. The crime of criminal damage requires proof that the defendant recklessly and without permission defaced or damaged property of another person. If you find the defendant guilty of criminal damage, you will be asked to determine the amount of the damage. Some definitions. Intentionally, or with the intent to, means that a defendant's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly means that a defendant acted with awareness of the existence of conduct or circumstances causing an offense. It does not mean that a defendant must have known the conduct is forbidden by law. Recklessly means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that conduct will result in. The risk must be of such nature and degree that disregarding it is a gross deviation from what a reasonable person would do in the situation. If the state is required to prove that the defendant acted recklessly, that requirement is satisfied if the state proves that the defendant acted intentionally or knowingly. Damaging or damage means any physical or visual impairment of any surface. Property of another means property in which any person other than the defendant has an interest. And property means anything other than a structure that has value, public or private, real or personal. I'm going to save the last 2 pages of your instructions until after the attorneys give their closing arguments, so we'll hold on to those. Okay. Ms. Ortman, is the state ready for its closing?
Yes, Your Honor.
Okay.
Can I have it?
There you go. Just a second. Is that the correct computer? Let's try it again. I think we'll give Ms. Ortman a moment to try to.
When it's in presentation mode, it should.
There you go.
Thank you. Ladies and gentlemen, you're here today because the defendant caused a path of fire in Pine, Arizona. On May 30th, 2024, around 4:30 in the afternoon, the Pine Fire Department had responded to mile marker 270 near Strawberry about a fire in the forest. It was later determined that several fires had been set in the area along an unpaved road or path. The areas for these fires were documented by the Arizona Department of Public Safety and Law Enforcement began looking into these fires. When the Forest Service arrived on scene, there was a witness, Mark Gatz, who talked to the officers and said he was in the area camping when he saw the defendant, a friend of his, walking down the road. He said he saw the defendant was yelling and he seemed to be upset, but the defendant was alone. He said shortly after that is when he noticed the smoke, and that's when he saw the fire department. Mr. Gatz then went to assist the fire department with controlling the fires. An off-duty firefighter, Zach Graham, was driving on the road at about this time, and he says he saw someone who appeared to be upset, pulled over to stop to help them, but that person made a rude gesture to his vehicle, and so he just continued on driving. The defendant was apprehended shortly thereafter as he was sitting on the side of the road. He was questioned after being read his Miranda warnings, and the defendant tells of his actions that afternoon. He talks about how he walked from his home at the Rim Shadow RV Park, walked up to Pine Strawberry, and then he met with his friend, Peter Bianca, who then gave him a ride down to HB's. He went to Tim Stuckey's. Then he went to Uncle Tom's, and he was walking back home when he was stopped at mile marker 268.5 at about 6:30 by Deputy High Street. He denies setting the fires, but he does admit that he was in the area at the time the fires were set. He also has 2 lighters on him. One is a Bic type lighter, and the other is a high-intensity torch lighter. And both of those lighters were inspected by law enforcement, and they were functional. Further, the Forest Service called out a canine tracker to see if the defendant's scent was in the locations of the fire. The canine got the scent from the defendant's shoes, which were collected when he was contacted by the law enforcement officers earlier, and the canine tracked the defendant's scent back through the 3 fire locations. Lastly, the Forest Service did an investigation into both the cost of the damage to the wildlands, but also an investigation into the ignition source. During inspection of the specific origin areas, 8 of 9 cause determination categories were excluded, determining how the origin of the fires was incendiary and human-caused. You heard about those categories and how that conclusion was reached. And it was determined the damage to the forest was about $13,144.35 in damages to restoration of the forest. And you heard about how that number was reached for the supplies, for the grass, the trees, the man-hours, the cost of gas, and how that total number was reached for all 3 fires and the approximately 1 acre. So, what does the state have to prove in this case? And the way I like to go about arguing what the state has to prove is there's some things, and Mr. Crawshaw told you in his opening statements, there's some things that he does agree with me on. And one of those things is I don't think Mr. Crawshaw is going to be arguing that the defendant had expressed permission, that someone told him, yeah, sure, we're going to do a controlled burn, we need you to go out there. I don't think Mr. Crawshaw is really going to be arguing his client had expressed permission to do this. I submit to you, the state still has to prove it, but I submit to you that there's no evidence that there was any express permission that the defendant was given to go out and start these fires. So ladies and gentlemen, I submit to you that there's just no express permission that's been given here, and the state has proven that there was no express permission. Defaced or damaged. You've been given the definitions of what defaced or damaged is. I don't think Mr. Crawshaw is really going to be pointing at the images of the forest and saying, hey, look, there's no burn marks here. We all can see that. Use your reason, common sense, and intelligence. The state has shown you these burn marks on the land. There's been testimony by various U.S. Forest Service people who were out at the areas. Even Mr. Gatz was talking about how he was assisting with the fires. So we know that the forest itself was defaced or damaged in some way. And then property of another person. I don't think Mr. Crawshaw is really going to be arguing that this was his client's property. We all know your reason, common sense, and intelligence tells you that this property was, in fact, the U.S. Forest Service property, which is therefore property of another. So what is really going to be what you are really going to probably be having some lengthy discussions about in the jury room, that leaves the defendant recklessly. I think that's really what you're going to have to decide, is was it the defendant and was he reckless? So how did the state go about proving that? So The state proved it was the defendant by a number of different circumstantial facts. One of them is Mark Gatz. Both Mark Gatz and Zach Graham saw the defendant in the area. Mr. Gatz tells you he saw the defendant, and then shortly thereafter, he saw the smoke. We all know your reason, your common sense, your experience tells you a fire has to be lit. It then has to be burning for a period of time for that smoke to drift, for Mr. Gatz to see it. So he sees the defendant. Shortly thereafter, he sees the smoke. By the time he goes to help the Forest Service, by the time he goes to see, there's already firefighters on scene working on the smoke and the fire. So Mr. Gatz also tells you that the defendant was alone, that he was by himself. There was no one else with him. So who else was seen in the forest at that time, that day? I submit to you there's no evidence of anyone else that was in that area. And in fact, Mr. Gatz told you he hadn't seen anybody else. Mr. Graham says he saw the defendant and the defendant was alone. So I submit to you that what Mr. Gatz and Mr. Graham tell you is consistent. The defendant had lighters on his person. He had 2. You have to have some sort of a spark to create a fire. Your reason, common sense, and intelligence tells you that. So when he was located, he had means to be able to start a fire on him. So it's not like when he was contacted, he had no way of starting a fire. He did, in fact, have 2 different ways of starting a fire. His scent was tracked by the canine from the 87 up through, and then the dog, you've seen the path, you have that in evidence. The dog then went and lost the track. You also heard from the canine handler about how scent drifts and things like that. And doesn't your reason, common sense, and experience tell you that that makes sense? That it makes sense that the defendant would take that shortcut up to go visit Mr. Bianca. And that the dog would, in fact, smell him going on that path. There's boot prints in the area. Now, it's your determination as to whether or not the boots that you have the pictures of the boots that Mr. Yoakum was wearing at the time. It's your determination as to whether or not those boot prints match. It's nobody else's call but yours. That's one thing for you to consider, that there were, in fact, boot prints that were found. And I'm not trying to say that they are, in fact, a match. That is your call to make. I ask that you take a look at the photos, compare them for yourselves, and make up your own minds. The fire investigation. That tells you that it had to have been human caused. You heard about how they ruled out every other possible cause of ignition for these fires. So it had to have been human caused. And who's the only human that was there? The defendant. And lastly, the defendant, when he's questioned, he tells you he didn't have a watch, he wasn't keeping track of the time, he wasn't sure about when he went here and when he went there. He was sure about where he went. He just wasn't sure about when he went. And so he admits that he was walking in that direction. Mr. Gatz tells you that the defendant was walking in that northerly direction in the cut through towards Strawberry. And so he tells you that, he just can't tell you when. And being seen by Mr. Gatz and being seen by Mr. Graham at about the time that these fires had to have started, because the smoke was shortly seen thereafter, doesn't it make sense that the defendant is the one who started the fires? So moving on to recklessly. How did the state prove recklessly? We know that the defendant was agitated. There's been some testimony that he was intoxicated, and Mr. Bianca said that the defendant was suicidal when he got to his house. So we know he was upset, basically having a bad day. And so when you're having a bad day, sometimes you make some reckless decisions. Sometimes you might say, well, I'm just going to let it all burn. Doesn't that make sense? For someone who's possibly suicidal, agitated, and upset to make that kind of a decision. Taking your lighter and setting fire to brush is reckless. That's just common sense, especially in Arizona, where things are so dry and fires are so easy to start. Your reason, your common sense, and your experience will tell you that that is reckless to do in Arizona. As to the amount, ladies and gentlemen, there was testimony that it was $13,144.35. You've heard about how that number is reached. You can accept it in part or in whole. It's your decision as to whether or not you agree with that number or it's something lesser. That's your decision. There will be more discussion of that with Judge Wright. He will tell you about that in your verdict form. He will discuss that with you. I'm asking that you find the $13,144.35. I believe the state, based on the testimony of the U.S. Forest Service, that that number makes sense. Now, it's not about the specific cost of the trees that he actually burned down. It's about what is it going to take to get that forest back to how it was, how it should be. What is that going to take? And it's going to take $13,144.35 worth of work and effort and supplies to do that. Or at least I submit that's what the record shows. So lastly, I want to talk to you about what's the state's burden. Proof beyond a reasonable doubt tells you that's the state's burden, but what is that? What is beyond a reasonable doubt? Well, it's proof that leaves you firmly convinced. It is not proof above all doubt. You must simply be firmly convinced. And it tells you that if you are firmly convinced, then you must find the defendant guilty. Not may, not could, not should, must. So if you are firmly convinced, you must find him guilty. Goes on to tell you that there are very few things that we know with absolute certainty. You are not required to be absolutely certain that it was the defendant. You are not required to be absolutely certain that he was reckless. You are not required to be absolutely certain about everything in this case. You are required, the state's burden is to firmly convince you. That is the burden. It is not proof that overcomes every doubt. You may have some doubts, but at the end of the day, if you are firmly convinced, then you must find the defendant guilty. And proof beyond a reasonable doubt is not perfect clarity on every fact and every issue in the case. It is that you must be firmly convinced. So the way I like to talk about an illustration for that is, if you think about going to sleep at night and close your eyes, you lay down, fall asleep, and then you are awoken in the middle of the night by a loud rumbling noise. You open your eyes, you see some flashes of light come through the window, and you hear water falling on your roof. I submit that's not a cause for concern. Most people would probably roll over and go back to sleep. The next morning, you wake up, you see everything is wet outside. I submit to you, you would be firmly convinced that it had rained the night before. Your crazy neighbor could come to you and say, hey, did you see that crazy water truck that was driving down the road, spraying water everywhere? making all that noise, had a big flashing light on the top. Did you see that? Your neighbor could come tell you that, but I submit without further proof, you would still be firmly convinced that it rained the night before. So ladies and gentlemen, I'm asking, and your verdict will tell whether or not the defendant was successful in causing a path of fire in Pine, Arizona. Thank you.
Mr. Crawshaw?
Yes, please.
And do we need to surrender the screen to you in just a moment?
If I can present.
Okay, we'll let Mr. Crawshaw present. Just a second. Should be, is that your screen?
Yes, sir.
Excellent.
It's not bringing up what I have on my screen.
There we go. Just a second. There you go. Okay.
So we have the singular criminal damage count to decide. And so I want to talk to you in my closing about all the reasons why it's not proven. During voir dire, we talked a little bit about evidence beyond any doubt based on reason, and then we're going to work down the list. The amount of evidence necessary for the state to take a child away is clear and convincing. The amount of evidence to win in an automobile collision case, that's just an example. But this is what's civil. And I'm stopping here for just a second because we're going to talk about it again in a minute. But this is also the burden, more likely than not, that the fire investigator arrived at, which was probable, just tipping the scales. We don't have more on that ladder regarding just causation by anybody than preponderance, which is slightly more than 50%, by the state's own testimony, the fire investigator, who didn't really see fit to bring out a second canine team. If, by some chance, you think that Mr. Yoakum did light these fires, let's talk about damage to the forest. The person in charge of putting together that report didn't go do any comparables. You wouldn't use this evidence to value your home if you were going to sell it. He didn't talk about how many trees were in the burned areas, the density of the grass. It was all based on judgment and experience, but we don't have something called foundation. So how do we get to this number? For money that hasn't been expended, for an area that there's no evidence that somebody had to stop using. There's absolutely no evidence that it was damaged at all beyond the 3 small burn areas. Furthermore, there's no evidence of where the cost actually comes from, other than this is what it would take, not what this is what we think it will take, not this is what we think these areas will take, based on the area around it. That's why the gentleman with the Forest Service said, or I say that because the gentleman from the Forest Service said he had not been out there to take any sort of measurements before. He didn't take any sort of measurements after, before he gave you that number. Mr. High Street contacts Mr. Yoakum where he had been sitting, not hiding, eating snack cakes, and he had a lighter on the ground next to him. He also had cigarettes. This is more common sense than what the state's argued. because you take a lighter out of your pocket when you're going to light a cigarette, sitting on the ground next to the road, not hiding from somebody. As we just discussed, or I just said, the fire investigator didn't complete a report. He didn't complete his report. We didn't get all the readings. He didn't go through the manual. He didn't do witness interviews. He didn't call out a canine team to find an accelerant, which he certainly could have. That's why Mr. Bissett, who was the state's first witness and was actually in control of the crime scene, like Yasnowski said, roped off the areas, roped off the burn areas, so that an investigation wasn't tampered with. But we don't have anybody that went in there to look at anything. Not the number of trees that were burned, not the sort of refuse that was burned, nothing. Why not go and speak with whoever was at the other side of the map before the dog doubled back into no man's land? There's not a good reason not to, not when you know people are over there. State's Exhibit 24, which is Mr. High Street's body cam video. Mr. High Street says he isn't worried about him going anywhere. This is the same man, Kenny, this is the same man who walks like Bigfoot up the trail, down to the edge of the map, goes back up past Mark's camp, undetected, goes back down the other side of Mark's camp, undetected, and then still magically makes it into Strawberry on the timeline the state has submitted. If he makes it into Strawberry when everybody else says he did, which I'm not arguing that he didn't go and do and go and see and go and light any fires on the way. Because Farnsworth testified that it took him and Bonnie's pulling on the lead, 29 to 30 minutes to make that triangle. That's more than the amount of time. If Kenny did that, he wouldn't be where Peter Bianca said he was. Because remember, his story was corroborated. And when people give you corroboration, that creates an alibi. And then working backwards from alibi, just because he walked through there doesn't mean he stopped with no time to spare and lit 3 fires. Now, it is a good thing, I suppose, for law enforcement and nobody else. Certainly not Mr. Yoakum. But it's a good thing for law enforcement that he wasn't sitting 20 yards off the road, because otherwise they'd still be sitting in the cars, not looking in the woods. Maybe somebody did go off into the woods, because Farnsworth was initially called out, because they still heard somebody in the woods. Maybe that dog tracked to the further east side of Mark's camp where he had lived for 5 or 6 years because she was following somebody else. We know the boot prints don't match. There's absolutely no way. And oh, see that 1831 right there on the bottom right of that slider, the bottom middle? When you play the video, which is State's Exhibit 4, it's going to have a timestamp up here, not just the minute marker. That timestamp says 1631, and that's when Mr. High Street stops him and questions him. And he calls into his mind. And he says he has some fear. Because you remember Mr. High Street's testimony about the dispatch log and how somebody reported somebody with a white beard and a dog? That's because that's who they were looking for. The only problem is Mr. Yoakum was on the side of the road without a dog. Now, Mr. Yoakum's presumed innocent, and we have that presumption to protect people from situations like this. The state gets to argue last, and maybe they won't, but they probably will, because it's their burden, and whoever carries the burden in this setting gets to argue last. For every argument, there's a counter-argument. If there's a counter-argument in your mind that you're not satisfied by, that means there's reasonable doubt. Don't release Mr. Yoakum's acquittal when issues you hold on to aren't resolved for you. We just said, High Street says he isn't in any condition to run, so I'm not too worried about you. Go back and watch stage 24. This is the same person who the state says went through the forest, lit 3 fires, and if you ever lit a fire, even in ideal conditions, he better have done it on the first strike. Then he doubled back opposite the direction of Mark's camp, went into the steep, brushy, rugged area, was clever enough to lose his scent until the dog picked it back up the last place he was seen. That's the only part of that dog track that makes sense, because we know nobody saw him up there. There was no fireman on that side of Mark's camp. The problem is that the problem for the dog, or for the state, is that Farnsworth says that is clearly his track, yet the state just argued against its own evidence when it says that's a shortcut. Anybody keeping the timeline that Peter Bianca, Mr. Stuckey, the guy at Tom's grocery store says he kept, or the Chevron, Uncle Tom's, says he kept, didn't do that. Didn't go around in that triangle and keep that schedule. Not somebody who smokes cigarettes and weed and eats Debbie cakes. There are people who could have kept that schedule, but they couldn't have stopped and lit any fires. So I'm going to ask you to remember your oath and please acquit Mr. Yoakum, because he's innocent and he didn't light these fires.
And Mr. Crawshaw, can you go ahead and take your boards?
Say it again.
Your boards?
Oh, yes.
Thank you. Okay.
Sorry.
That's okay. And I'll note for the record that those are boards of exhibits that have been admitted, so. Okay. Ms. Ortman, do you need back control of the screen or not?
No.
Okay.
Ladies and gentlemen, I'm here to appeal to your intelligence, not insult it. I'm asking for you to look at all of the evidence. Not just one piece, not just one person, not just one part. I'm asking that you pay attention to every single witness that has testified in this case and all of the state's exhibits. Because all of them, I submit, have pieces that help you come to the conclusion that the defendant is the one that set these fires. Because doesn't it make sense that the defendant would be taking a shortcut when he's walking? Like Mr. Crawshaw points out, Deputy High Street is saying, you're in no condition to run. Mr. Gatz says he only saw him one time. So, and the dog sniff, when it comes to that, I submit, corroborates the belief that the defendant left the 87 because it's dangerous to walk on, took the shortcut to Strawberry, and lit some fires on his way with his high-intensity torch lighter or the Bic lighter. Take your pick. Not that he was going around and running through the brush. And Deputy Farnsworth tells you that scent can drift and the dog can follow it. And the dog lost the scent further away. And then when they came back down, the dog picked up that same trail. So I disagree that the state's evidence is conflicting here. I submit to you that that's all consistent. All of the levels of proof that Mr. Crawshaw put on the screen, there's only one of those that matter. The only one that matters is proof beyond a reasonable doubt, because that's the only burden in this case. Proof beyond a reasonable doubt. And what is that? Firmly convinced. Proof that leaves you firmly convinced. I'm not going to beat that dead horse again, but that is the burden the state has to prove. With regards to the amount for the damages, the Forest Service told you that you can't keep track of every single tree. It would be unreasonable, and he told you the manpower it would take would be pretty big for the Forest Service to be able to keep track of every single tree on every single acre of the entirety of the land for the Forest Service. So, he provided his opinion and his analysis on how he came to what it would cost to restore that land. With regards to the fire investigator, he tells you he was called out to be an unbiased fire investigation. And isn't that what you, the jury, would want, is an unbiased fire investigation? If he started performing law enforcement duties, like interviewing witnesses, I submit to you, that would take away that unbiased portion of the fire investigation. And ladies and gentlemen, I submit that the defendant didn't go anywhere undetected. He was detected taking the shortcut to Strawberry by Mr. Gatz and Mr. Graham. With regards to the man with the white beard and the dog that Mr. Crawshaw talked about, Deputy High Street was asked about it, but we don't know where that information came from in that call log. We don't know who said that. I submit to you there wasn't a person that took the stand and testified about seeing somebody else in the woods that day. So where did that come from? Is that something that you can really have any information about beyond the fact that a question was asked about it? Now, with regards to Mr. Farnsworth, Deputy Farnsworth getting called out because someone was hurt in the woods, Mr. Gatz tells you that he heard the defendant in the woods. Mr. Gatz relayed that to law enforcement, that he heard the defendant and saw the defendant. Do you believe that all of that was clearly relayed to Deputy Farnsworth? Has anyone here ever played the telephone game? What happens when you play the telephone game? Things get left out. So doesn't it make sense that Deputy Farnsworth at the beginning was told that someone was in the woods? Because isn't that consistent? I submit to you, isn't that consistent with what happened in this case? Now, so far as the dog tracking somebody else in the woods, I submit to you that's completely inconsistent with Deputy Farnsworth's testimony, because those pictures of those boots, those are the boots that the defendant was wearing that the dog got the scent from. So does it make sense that the dog who can do scent discrimination is following somebody else? I submit it doesn't. Ladies and gentlemen, I submit to you this was not a rush to conclusion. This was a reasoned decision based on the totality of all of these circumstances, based on all of the facts that there were two people who saw the defendant in the woods, that his scent was tracked there, that the defendant was angry and he was agitated, that he had lighters on him, that there were foot impressions, boot impressions, his own admissions that he put himself there. Ladies and gentlemen, your verdict will determine whether or not the defendant was successful in causing a path of fire in Pine, Arizona. Thank you.
Members of the jury, I'm now going to give you the last 2 pages of your instructions. Okay. And this is on page 22 of your instructions. The case is now submitted to you for decision. When you go to the jury room, you will choose a foreperson, and he or she will preside over your deliberations. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during any breaks or recesses. The admonition that I have given you during the trial remains in effect when all of you are not in the jury room deliberating. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and should be signed by either the individual juror submitting it or by the foreperson. I will consider your question or notes and consult with counsel before answering it in writing, and I will answer it as quickly as is possible. Remember, though, that you are not to tell anyone, including me, how you stand numerically or otherwise until after either you have reached a verdict or you have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You must not use any electronic device or media, such as a smartphone or computer, the internet, or a social media app, to communicate to anyone any information about this case or to conduct any research about the case until I accept your verdict. All 8 of you must agree on a verdict. Your verdict must be unanimous. Once all 8 agree on a verdict, only the foreperson needs sign the verdict form on the line marked foreperson. You will be given forms of verdict or a form of verdict. There's no significance to the order in which the options of guilty or not guilty are listed on that verdict form. Okay. I'm sure you were all listening closely, and you heard at the end that I used the number 8, and I know you can all count, and you know there's 10 of you. Typically, when we pick a jury, I pick one alternate for each week of the trial that we may utilize. So this was originally thought to be 2 weeks. So in just a moment, the clerk is going to pick 2 of your numbers, and it will just go right down the top row. Are they seated in the order they were? So 1 through 4 is on the top, 5 through 10 on the bottom. I'm going to tell you what happens now, because sometimes if your number gets picked, it's like in school, you stop listening to me. So if your number is picked, when you go back to the jury room at this point, you're going to be physically excused, but you are subject to callback. It's possible during jury deliberations that a jury member or a family member of a jury member might have an emergency, and therefore we need to call you back. So you are subject to callback. When you are released from your jury service, and Mark will give you a call, either saying we need you back or the jury has been excused, then you can talk to people about the case. But even though I'm going to physically let you leave the building today, you're still subject to the admonition about the case until the case is fully over. Okay, so we're going to pick 2, Madam Clerk, and we do lots of things with technology. This one we have checkers in a fishbowl. So, okay, who's our first one, Madam Clerk? Okay, juror number 3, you'll be our first alternate. Let me write this down. And our second alternate is going to be juror number 1. So both of our jurors. So again, stay with me for a few minutes. Okay. So again, juror number 1 and 3, when we excuse you, you're going to be physically able to go, but you are subject to recall. Mark's going to hold on to your notes so that if you come back, you'll have the notes. If you don't come back, he'll destroy those along with, at the end of the case, with all the other juror notes. Okay. Mark, if you could come, Mark and Yoli, if you could come over, I'm going to have the clerk swear in. You've already met Mark. We also have Yoli Spurgeon, who's our second. She's more of our technology bailiff in case we run into issues in the jury room. So if you could both raise your right hand, and the clerk is going to swear you in.
Do you solemnly swear that you will take charge of this jury, that you will keep them in a private and convenient place, and not permit any person to speak to them or speak to them yourself, unless it be to ask them if they have agreed upon a verdict, and to return them into court when they have agreed so help you God?
Okay. Members of the jury, when you go back to the jury room, the 8 of you who will be deliberating, you're going to watch a short video on utilizing the digital evidence system we have, because there will be no one in there while you're deliberating except you. And I found you're not the first jury to do this, and I think the video must be good. I haven't watched it because our jurors generally have had success going through the videos, hearing things, that type of thing. I've actually heard that the sound is better in the jury room than it is out here, which maybe isn't saying a whole lot. But if you have questions about using the digital evidence portal or pulling up exhibits, if you let Mark or Yoli know, they can assist you with operating the system. If they are called in to assist you, you need to pause your deliberations. They will assist you with any technology issue you have. Then once they leave, you can deliberate again. So the only time you're deliberating is when they're the 8 of you and no one else. I'll also let you know at this point we're going to be on your schedule. You've been on our breaks for the last 2 days, 3 days. We're now on yours. I'm going to ask Mark to come in at about 11:30 and ask if you would like him to go ahead and get lunch ordered for you, as I mentioned before. You can let us know where you're at that point. Okay, there is one verdict form that Mark will be bringing back to you. At the top of the form, it says, "We, the jury, duly impaneled and sworn in the above entitled action with regard to criminal damage committed on or about May 30th, 2024, upon our oath do find defendant Kenneth A. Yoakum," and then there's 2 boxes you can check, either not guilty or guilty. If you find the defendant guilty, if you find the defendant not guilty, let's start there first, you're done. You don't need to do anything else on the form. If you find the defendant guilty, then there is a question for you to answer. And again, you only get to that if he's found guilty. And it says, if you find the defendant guilty, what is the dollar amount of property damage caused by the defendant? And then there's a line for you to put in a dollar amount there. Okay. Mark, can I come give that to you? Okay. Ms. Ortman, anything else before I excuse our jurors?
No, Your Honor.
Mr. Crawshaw?
No, sir.
Okay, so I'm going to excuse our jurors, juror number 1 and 3, if I don't see you again. Thank you for your service. I hope you understand that your time was not wasted. We needed to have you here. And I'll excuse all our jurors. Counsel, if you could please remain. Okay, please be seated. Counsel, I'll note that alternate 1, if we need a callback, alternate 1 will come back first, as alternate 1 was picked or juror number 1 was picked first. Oh, 3? Oh, it was 3. I'm sorry. 3 would come back first because 3 was picked first. Thank you, Madam Clerk. Okay, Mr. Crawshaw, if there is a guilty verdict, does your client wish to have the aggravating factor of victim harm submitted to the jury? Or he has 3 options. He can submit it to the jury, he can submit it to the court, or he can admit it. Which would he like, or do you need a moment with him?
I'm not there.
And Mr. Crawshaw, if you need to step Do you need to step aside so your client can hear you? I know there's...
But I don't know what that means.
Okay, we'll go talk.
Okay, so let's do this. Mr. Crawshaw, I'll give you several minutes to speak with your client. Ms. Ortman, as to counts 2 and 4, does the state wish to make any additional argument to the court on those counts?
Your Honor, there's additional elements there. I don't think that those additional elements are really what's in contest here. It's really the defendant and mens rea, and so I don't have any additional argument as to how it's the defendant with regards to those counts versus the criminal damage.
Okay, and there would be 2 mens rea if the court could either find him not guilty, guilty with the criminal negligence mens rea or the reckless mens rea. What is the state's position on the mens rea?
And Your Honor, I think that there's sufficient evidence for the court. It's the same arguments that I have as to his mens rea for the reckless or the criminal negligence.
Okay, and Mr. Crawshaw, would you like to make additional arguments on counts 2 through 4 to the court?
One of the things, I would say what I said already in my closing, but I would also argue that it bears against a finding of guilt in that Mr. Yoakum wouldn't have lit the forest on fire around his friend that he's known for 20 years.
Okay. Counsel, I'm going to consider that. I'll plan on issuing my ruling on that when we come back after Mr. Crawshaw speaks with his clients about the submitting to the jury. The reason why I need to know that now, Mr. Crawshaw, if your client does wish to have it submitted to the jury, I have some draft instructions and a verdict form. We just need to have those ready. Mr. Yoakum, I don't know what the jury is going to do, but I do need to have that form ready, so if they come back with a guilty verdict and you desire to have them hear that, we can go from that. Okay? Counsel, when we will also at some point, either before or after the jury verdict, discuss the other matter, do it in trial setting conference on that, and then depending on whether necessary or not, set sentencing on this matter. Counsel, will it matter what we do on the second case, the verdict on this, or is that just going to need a trial setting conference, or are we just going to need to pick a trial date on that one? Ms. Ortman, is that something maybe you and Mr. Crawshaw can discuss over the break as well?
I'm happy to discuss that with him.
Okay. If we come back at 11:20, Mr. Crawshaw, is that long enough for you to discuss with your client whether he wants to have a verdict or jury hear it? And then also, you can speak with Ms. Ortman about the next steps on the other case as well?
Yes.
Okay. Let me go ahead and do this. Let me see here. I'm going to go ahead and, Madam Clerk, can you print out what I just sent you? I'm going to go ahead and print for you, if it goes to the jury, what the draft instruction and verdict form would look like. That way, if your client, Mr. Crawshaw, wants that, you can look at that form as well. I don't think it's anything out of the ordinary. The one thing that I have done, under victim harm, I think it would only be financial, as the Forest Service is the alleged victim, and I don't think the Forest Service can have physical harm as to a body or emotional harm, so it'd only be, so I've shortened that down. So did those come through? There should be a total of 3 pages, 2 on the instruction and then 1 on there was 2 attachments, I think, wasn't there? Is there 2?
Oh, yes, sir.
Okay. And Mark, can you provide these to counsel? And then just a second, there's going to be a verdict form. Okay, and then I'll see everybody back to about 11:20. Thank you. return to the record in State versus Yocum, CR 2024-289. I'll note the presence of counsel and the defendant. Mr. Crawshaw, as far as the potential aggravator, how would your client like to address that?
We're going to elect to go to the judge, to the court.
To the court, okay. I think I need to do a brief colloquy with your client to make sure he's aware of his rights, not to disparage you, but just to make sure that if there is an issue later. Mr. Yocum, you discussed with Mr. Crawshaw that you can have the jury hear whether there is an aggravator or not. Is that correct?
Yes.
Okay. And let me ask, have you had any, and I'm going to go through some of these things, because you're waiving a jury on that, I need to make sure you're aware, okay? Have you had any drugs, alcohol, or medication of any type in the last 24 hours?
No.
Okay. And has anyone forced you or threatened you in any way to get you to potentially waive a jury finding on that aggravator if it becomes necessary?
No.
Okay. And let me just take a look. If you're convicted of the criminal damage, it could be anywhere from a Class 2 misdemeanor to a Class 4 felony. Let's talk about the felonies. If it was a Class 6 felony, the presumptive is 1 year, which would be the maximum without any aggravators. If it was a Class 5, the maximum is 1.5 years without any aggravators. And if it was a Class 4, it's 2.5 years without any aggravators. If the jury or the judge were to find at least one aggravator, then it could go up to 2 years on a Class 6, 2.5 years on a Class 5, and 3.75 years on a Class 4. Do you understand how that could there's no guarantee that it would increase, but it opens up that possibility. You understand that?
Yes.
Okay, and with all that information, and after speaking with Mr. Crawshaw, you'd like that decision to be made by the court if necessary?
Yes.
Okay. Madam Clerk, if you could note that the court has found that the defendant knowingly, intelligently, and voluntarily waived his right to have a jury finding on the aggravator if necessary. If that becomes necessary, the court will make that finding at some point in the future. Okay. As to counts 2 through 4, those are now potential misdemeanors. The court has considered the evidence that has been admitted and only the evidence that has been admitted. As the gatekeeper, the court during the trial has reviewed other evidence, but for the purpose of this ruling has ignored anything other than those exhibits that were admitted. The court does find the defendant guilty as to counts 2 and 4. The court finds that the mental state that is applicable in this case is reckless, and therefore I believe that that would make those a Class 1 misdemeanor. Okay, so counsel, I'm going to set sentencing on that in just a moment. As far as the other companion case, 2025-311, did the parties discuss what might be the next step on that?
Your Honor, I think we would like the court to set an interim hearing so that we can have some further discussions between ourselves as to whether or not we're going to do a plea or a set trial, and I think we'll have a decision by then.
Okay, Mr. Crawshaw, do you confirm, do you agree with that?
Yes, and it's not guilty on count 3.
I'm sorry, 2 through 4. 2 inclusive, 2, 3, and 4.
As a what level?
The reckless, which I believe is a Class 1 misdemeanor. Okay. So, Madam Clerk, I'm going to set this matter for sentencing and the other matter for a trial setting. Mr. Crawshaw, I think you'll be in Globe on October 27th. I think that's one of your regular days. That's in about 3.5 weeks. There wasn't any days in October where you were unavailable, correct?
Yeah, I'd like it not to be until November because of preparation. I'm trying to avoid as much in-court time as possible.
Okay, so you're willing to waive time, November 3rd, just a second, let me see what the second Monday in November is going to be. Ms. Ortman, any objection to going to the second Monday in November?
No, Your Honor.
So, Madam Clerk, I'll utilize, let's see here. November 10th, and I will set that at 9:45 on my Globe calendar. I'll order that the defendant be personally present. And at this point, I'm going to, counsel, if the sentencing is only as to the misdemeanors, then I'm going to order just an abbreviated report. If the sentencing includes a felony verdict by the jury, then I'm going to order a full pre-sentence report. So I'm going to wait on the pre-sentence report, but if you could remind me at the end that I do need to address that. So that'll be sentencing in this matter in I'll call it a trial setting conference in 2025-311. And I'll find that time in 25-311 is excluded between now and then. Okay. The jury has informed Mark that they do want to order lunch. That'll give you an idea. Mark, realistically, by the time lunch gets here and they eat, it's going to be no sooner than 1 right? So counsel, if you need to step away to have a meal, feel free to do so. If you could just make sure that Mark, I think he does have your cell phone numbers. Detention staff, Mr. Crawshaw, if there's a jury question, is your client going to want to be here for that?
Yes.
Okay. So, Mark, you're just going to take him back across and feed him and just keep him over there? Is that would be the plan?
Does he need to be here for questions?
Well, yes, but we don't know if we're going to have any. So I'm thinking you can take him back over and you bring him back if you need him. But I don't think there's a reason why he needs to stay here. If you want to go ahead and take him across the way, make sure he's fed. You guys been going out this door? Okay, and again, I think our jurors are pretty much been staying inside, but if you could exercise caution if you go out this side and then go around the front of the state. Are you going in the front or the back now? Okay, so that way, even if the jury glanced out, I don't think they would see anything, which we need to do. Okay, Ms. Hortman, anything else then before we break?
No, Your Honor.
Mr. Crawshaw?
No.
Okay, then counsel, we'll see what the jury does. Thank you. Ready? We'll go on the record in State versus Yocum, CR 2024-289. I'll note the presence of counsel and the defendant. We have a jury question. The jury question, which I believe has been shown to counsel, is can we see the map of everywhere he went? The state showed it during closing arguments. Counsel, I think that hopefully I think the bailiff showed you what I think my answer probably would be, which is what the attorney said and shared during closing arguments is not evidence, although you may use it to help you understand the evidence and law. The evidence is what was testified to from the witness stand and the exhibits that were admitted. Ms. Hartman, do you have any objection to that or any other thoughts?
The only thing that I'd like to put on the record, just so the record is clear, is that what I showed during closing arguments is the exhibit that was the illustrative that I used during my presentation of my case in chief.
Okay.
And so it was not admitted as evidence because it was specifically used for illustrative purposes.
And I guess if it's that exhibit, potentially the parties could stipulate to sending it back, because that is one of the options. I don't know what the party, let me just pull up the rule. It's relatively new, and then Mr. Crawshaw, I'll hear from you in just a moment.
I don't take any issue with the court's decision.
Okay, so you'd like to have just that answer. Do you think it should go back or not, or do you care?
We agree with Ms. Ortman.
That what, you don't have any objection if it goes back?
No.
Okay. So I'm looking under Rule 107B2, talking about illustrative aids. It says an illustrative aid is not evidence and must not be provided to the jury unless, and number one is the party's consent. So I think it's a strange thing because I think I'm going to send it back to them, but still, it's still not evidence. So I think I need to answer that. What exhibit number is it marked as? 43? Okay. So exhibit 43.
Oh,
Yes.
because it's not it.
Because if you want to look at Rule 107,
Yeah. Well, I don't want it to confuse the issues. Like,
well, I think I could tell them that it is not evidence, but may be used to help them, but maybe illustrative of the evidence. Because even if it goes back, P9, it's P9. So it's P9. I mean, I think it's, even if it goes back to them, it's still an illustrative exhibit that, according to the definition, is, it basically falls within your, same way they could treat your closing arguments. So, but there has to be a consent if it goes back.
I
well,
think we
that's
have.
because it's requiring that additional instruction that I'm debating.
Well, yeah, I mean, I'm not just gonna, I think,
I'm debating whether to stipulate at all.
okay, why don't you think about that for a minute? I'm gonna draft up some language if you do stipulate or you do consent.
Judge, I'm not authorized to stipulate.
Okay. So if there's not consent, then I think I'm going to go back to the original. Ms. Ortman, you had no objection with just what the attorney said and showed you during closing arguments is not evidence, although you may use it to help you understand I guess it should be the law and evidence. That's basically, I'm repeating the prior jury instructions, but not telling them that. The evidence is what was testified to from the witness stand and the exhibits that were admitted.
Well, Your Honor, I'd ask that the court, under B2, it says the court for good cause orders otherwise, and I think there is good cause here.
Okay.
I think it will aid them in their deliberations, one way or the other, and help them reach a verdict, and I think that there is good cause.
Mr. Crawshaw, do you want to be heard on the argument by the state that it should go in under A2, or B2, excuse me?
Judge, I don't know exactly what that illustrative exhibit shows. I didn't exactly
Do
cross.
you want to look at it? It should be number 9, is what Ms. Ortman, the clerk's telling.
No, I did not. He used 9. I used 43 in my close.
43 is the one at issue, so let me pull up.
Yes.
We can all, I think it is important that we're all taking a look at
I mean, I
43.
could have entered, technically, I think I could have entered it as evidence, because I definitely laid foundation for it. I had all the points testified to. I could have entered it as evidence. I made the decision to keep it as illustrative.
It's number what?
43.
43.
And we can open theirs back up. Or do we- Mark, can you get Yoli? Okay. She's still, she coming? Okay.
That's not where Uncle Tom's Food Court is. What is that Uncle Tom's Food Court? Is that Uncle Tom's Food Court?
Yeah, the Chevron, right on that corner.
No, the Chevron's.
What? See in the Pine Market, right there. The Mormon church is right there.
And Mr. Crawshaw, you may want to turn off your microphone there on the table.
No.
Okay. Okay. Mr. Crawshaw, are you ready to address the state's request for that it go back under B2?
Yes, Judge. No, I think that's fine.
Okay. So you're not consenting that it goes back, but you're not going to disagree with Ms. Ortman's, you're not going to formally object to it going back with Ms. Ortman?
That's correct.
Okay. So counsel, here's the language that I'm going to send back with it. Exhibit 43 is an illustrative exhibit. It is not evidence, but may be used to assist the jury in understanding the evidence and/or arguments of counsel. And then hopefully by the time we send it back, I'll be able to tell them Exhibit 43 is now available for their viewing. I'll note for the record, just so the record is clear, that if it would have been offered at the time, the court most likely at that point would have admitted it as an exhibit. There appeared to be relevance and foundation. I just note that as a side issue. It was not offered. Okay. Counsel, it may take us a little while to figure out the tech. I'm not sure we've had to reopen after we send it to the jury because we're always very careful what goes back to them. Ms. Ortman, anything else on that question?
No, Your Honor.
Mr. Crawshaw, anything else on that question?
No, sir.
Okay, let me ask counsel just one other thing, and this is more if there's a conviction and if at some point there's a Rule 32 motion. Mr. Crawshaw, there was a reference to a person with a dog or something like that on the side of the road, and I believe yesterday you actually did, or was it yesterday you interviewed, or today you interviewed someone related to that?
Yesterday.
Yesterday, okay. Again, I just want to make sure the record's clear, so you're protected, the case is protected. You did investigate that, and based on your investigation, you chose not to take, strategically, you chose not to take other actions on that.
No, it wasn't strategic. I'm not waiving my error. The thing is this.
Okay.
Is that I have all the information I'm able to get at this time. We've thoroughly investigated it.
Okay, but based on the information you have now, you chose not to call any witnesses?
That's right.
Okay, I just want to make sure the record's clear so that in a year, if there's a conviction in a year or two, when another attorney is looking at you, they know that you did the interview, you made the decision based on the information you had, and that you didn't ignore it. That's just
right. We may go out in a week
Okay,
and find
okay,
somebody that's exactly like that was camped further into the woods.
right. But based on the information, you did investigation, and based on the investigation you did, you chose not to do anything further.
That's right.
Okay, and again, I just want to make sure, it would be easy for some attorney later on to just say, oh, Mr. Crawshaw just blew that one off. He did not, he did the requisite investigation available today. I realize you're not waiving anything into the future, but absent new information, you chose not to take any further steps.
Yes.
Okay. And again, Ms. Ortman, anything you want to add on that?
No, Your Honor.
And Mr. Crawshaw, again, anything you want to add on that?
No.
Okay, then we'll be back at recess until we have a question or verdict. Okay, so. Okay, we'll go on the record. A second here. In State versus Yocum, CR 2024-289, I'll note the presence of counsel, the defendant, and our jurors. Members of the jury, have you reached a verdict? Yes. Okay, and if you, whoever is the foreperson, if they can hand it to Mark. And Michelle, I'm going to ask you to read it. Okay. Okay. I'll ask the clerk to read and record the verdict, please.
Arizona Superior Court, Gila County. State of Arizona plaintiff versus Kenneth A. Yocum defendant. Case number CR 2024-00289. Verdict, count 1. We, the jury, duly impaneled and sworn in the above entitled action with regard to criminal damage committed on or about May 30th, 2024, upon our oath do find the defendant, Kenneth A. Yocum, guilty. If you find the defendant is guilty, what is the dollar amount of the property damage caused by defendant? $9,418. Signed jury foreperson.
Okay. Ms. Ortman, would you like the jury polled?
No, Your Honor.
Mr. Croshaw, would you like the jury polled?
Yes, please.
Okay. Members of the jury, the clerk is going to ask each of one of you, just starting in the top row, if this is your true and correct verdict, and you'll either answer yes or no. So she'll just go top row, 1, 2, and then right down the front. Okay?
Juror 2, is this your true and correct verdict? Yes. Juror 4, is this your true and correct verdict? Yes. Juror 5, is this your true and correct verdict? Yes. Juror 6, is this your true and correct verdict? Yes. Juror 7, is this your true and correct verdict? Yes. Juror 8, is this your true and correct verdict? Yes. Juror 9, is this your true and correct verdict? Yes. Juror 10, is this your true and correct verdict? Yes.
Okay. Thank you, Madam Clerk. Members of the jury, this is going to conclude your service on our jury. The admonition is lifted. You can speak to anyone you choose to or not speak to anyone you don't want to speak to. I'm going to handle just a real quick bit of business, potentially with the lawyers. If you have a couple of minutes, and I'd like to come back and personally thank you. If you need to get on your way, I understand that as well. So fortunately, we ended this week, so you'll have next Wednesday. If you cleared your plans, you now have a free day to do whatever you were going to do anyways. But okay, thank you. With that, we'll excuse our jurors, counsel, and the defendant, if you could please remain. Okay. Okay. Okay, I'll note the absence of our jurors. Counsel, first, as to the aggravator of victim harm, Ms. Ortman, would you like to make any additional argument on that?
No, Your Honor.
Okay, Mr. Croshaw, would you like to make any additional argument on that?
Yes, please.
Okay,
Judge, the financial harm is also an element of the offense, and so I don't know that it can be alleged as an aggravator because of that, in the same way that a deadly weapon cannot be alleged as an aggravator of a crime that involves dangerousness or involves the deadly weapon as an element. Because criminal damage is necessarily contains financial harm as an element. If the jury would have found 0, we would have had to instruct them to enter a verdict of not guilty, I believe, which could have been possible. In other words, like it's possible that the jury could have found him guilty and then also said $0 in damages. And so I don't think that the aggravator is proper to be found in this case.
Ms. Ortman, in this manner where the only victim harm could be financial because it was a corporate victim, I'm inclined to lean towards what Mr. Croshaw told me or is arguing. If in fact this was an individual victim, then I think the charge would have a financial aspect, but they could also suffer either emotional or some sort of other harm. Would you like to be heard on that?
Well, Your Honor, I think that the finding of the dollar amount in this case is necessary for a sentencing provision and not necessarily as an enhancement thing. And so I believe that the court can, because this is for an enhancement for a sentencing provision.
The court will note that the court will note that there is victim harm in this matter, but I'm going to make a finding as of right now, and Ms. Counsel, if you want to re-urge this, the legal finding in advance of sentencing, you're free to do so, but I believe that it does at this point merge into the offense. Ms. Ortman, again, if I'm wrong on that and there's case law and you want to bring that to my attention, I'm making a finding of harm, but find that it's merging in. So, okay.
So is my argument sustained, so we're clear?
Yeah, so, I'm making the finding, I'm making the factual finding that there is harm, but I'm going with your legal argument that that harm is merged into the offense, therefore there is not an aggravator.
Thank you.
Subject to, again, if in advance of sentencing, if there's a case that shows that I'm wrong, I've made the factual finding so then I can reconsider the legal finding. Okay, now, Ms. Ortman, you've alleged prior felonies as well?
I have, Your Honor. So the state moves into evidence for the court's consideration for sentencing. State's Exhibits 18, 19, 20, and 21. They are all certified priors as well as a certified PIN pack. So they're self-authenticating documents.
Okay, so that's 18, 19, 20, and 21?
Correct.
Okay. Mr. Crawshaw, do you have any objection to those being admitted?
1 moment, please.
Okay.
Judge, can we recall this issue? Because I didn't have the exhibits pulled up.
So how much time, if I just
I'm
take a
sorry,
moment,
but-
thank the jurors, and then come back in 5 minutes, will that be sufficient time for you to review
No,
those?
I haven't pulled up. It's
Okay.
18, 19, and 20.
And 21.
And 21.
Judge, we're going to object on the basis that I don't know that they're all certified priors. Number one. Number two is not all of them he was sentenced to prison on, which may not be a requirement. I'm still objecting on that basis. And number three is I don't know that he's been properly identified as the person named in the priors.
Okay. I'll note Mr. Crawshaw's objections. Over his objection, I'm going to admit 18, 19, 20, and 21. Ms. Ortman, do you have any other evidence, or is that all you have?
That is it.
Okay. And Mr. Crawshaw, do you have any, and I'll probably hear a short argument just from the parties in just a moment, but Mr. Crawshaw, do you have any evidence you'd like to present on the issue of the priors?
No.
Okay. So, and counsel, so those have been admitted. Ms. Ortman, am I correct? And counsel, in advance of today's hearing, I reviewed those just in case necessary. Ms. Ortman, you're the actual, there's three felonies alleged there. You're only alleging two of those would be historical, the DUI because the DUI is a forever prior, and then the weapons misconduct as a third?
Your Honor, I think that ag DUI, they might have changed, I believe they've changed that sentencing provision from that being a forever prior. It's only forever prior for other DUIs at this point in time.
Okay.
Under,
So, well, let me ask this, do you think I probably should make findings today for our pre-sentence staff. I think that is probably something we should address.
and so, I know the statute, I think it's 13105. It's under the definition of historical prior felony conviction, subsection 22. So subsection 22A4, this item applies only if the offense for which the
Okay.
historical prior felony conviction is a violation of 281383, which this case is not.
Okay, so you're asking me to find three priors, but only one historical prior?
Correct.
Okay, and any additional argument you want to make on that?
No.
Okay, Mr. Crawshaw, any argument you'd like to make on that?
Not at this time.
Okay. So, Madam Clerk, I will find that the defendant has three prior felony convictions. And let me just pull these up. And Madam Clerk, if you want to check your email real quick. I'll note that, why don't you pull up here, that the three prior felony convictions would be aggravated DUI out of Gila County, case number 04422 with a sentencing date of January 1st of 2004. The second prior would be possession of drug paraphernalia, also out of Gila County, 2009-492 with a sentencing date of 11/19 of 12. And finally, a weapons misconduct charge, again out of Gila County, September 22nd of 2014, case number 2014-13. The court will additionally find that the weapons misconduct is a historical prior. So I will go ahead and direct that the probation staff prepare a full pre-sentence report, noting that the defendant does have one prior. Counsel, I believe with the damage amount that the jury came back with, it's now going to be a Class 5 instead of a Class 4. I see Ms. Ortman nodding in agreement, Mr. Crawshaw. So, Madam Clerk, if you would note that that on the criminal damage, it's a Class 5 with a prior. If you could also note on the reckless burning charge, and at some point we'll need this, I'm sure, the sentencing statute will be 13-1706C2. I'm sorry, C3. No, C2. 13-706C2 it was 4, it got amended to 3. The finding is actually on subsection 2. 2, 3, and 4, yes. Okay. I've already set a sentencing date. I'm going to affirm the defendant's current release conditions, which he's being held in this matter. I don't recall the exact bond, but I think it's $5,000. That's in the other case.
500 cash.
Oh, is it the other way around? Okay. Thank you. So a no bond hold in this case and 500 on the other case. Ms. Ortman, I'll order that any exhibits that were not offered may be removed from the digital evidence portal. All those that were submitted in any form will be retained. Ms. Ortman, anything else?
No, Your Honor.
Mr. Crawshaw.
Just for my notes, because I know it's going to be, just for my notes, because I know it's going to be a minute before we get the minute entry out. What was the amount the jury found?
$9,418. Okay, then with that, we'll stand at recess. Thank you. And Mr. Crawshaw, I suspect what they...